recording this session. I just started recording, so it will be made available to you after today's presentation. Now, everybody here today, you will have the chance to meet with me at a later date to discuss your particular estate plan. Jim will be joining us shortly.
I'm here.
Good morning, Jim. How you
just
doing?
need to let me. You need to allow me to have the video on.
Oh, yeah, you got it.
All right.
So today, our presentation, it is going to be for educational purposes only. It is not legal advice, and that's because we haven't seen your unique situation. We haven't seen what makes you different from everybody else, what your family issues are, what your assets are, and so everything today is for educational purposes only. It is not legal advice. So Jim founded this firm in 1995, 1994, one of the two.
Yes, something like that, a long time ago.
Last century. And we have 7 attorneys now. We have offices throughout California. We do meetings via Zoom during this time, but a lot of us will meet with people in person. We do masks, all that good stuff. Our offices are very clean. We do signings outside. But really, Zoom has been our theme this year in 2020. Jim, why don't you tell me a little bit about yourself?
Yeah, well, I'm a second generation lawyer and a third generation pilot. My grandfather was a pilot. Both my parents were. My mom was actually an air taxi pilot. So any pilots out there? She's an air taxi pilot in Alaska back in the day. And, it's for the last 25 years, 26 years, we've just been working hard, helping families set up their estates and helping families go through the process when a loved one passes away or becomes incapacitated. So there's a lot of mystery around this, and there are a lot of hidden traps for the unwary that can result in paying a lot of taxes that you didn't even know were out there. And so our job here is just to help the families go through this process. And Connor, you're entering a field at a very exciting time, and you've been an attorney how long? How many years?
4 years.
4 years, and you have an advanced degree in taxation, which is called an LLM, which not many lawyers have. All of these 7 lawyers that you see here are all, the only thing that we do is trust and estate work. So helping people set up living trust, helping people work through them. If you have to go to probate court, we help you with that as well, but that is not our focus. Our focus is not to send you through probate court. But I'm really excited about today because we're gonna talk to clients and hopefully their children or other loved ones, but primarily it's children. And there's a lot of stuff that you didn't know that you don't know. So the stuff that you don't know, and stuff you don't know, and that is what gets you into trouble. Sort of these unknowns, if you will. But
So I mean, today's presentation, that's exactly it. We're going to be talking to hopefully these multiple generations because we talk to our clients quite a bit about what to expect when they pass away or become incapacitated, but we don't oftentimes talk with their children, who are the ones who are going to be kind of running the show at that time. Now, at our firm, we've realized that the majority of people, they will become incapacitated at one point in their life. We see it all the time. And a lot of people, when they think about estate planning, they think about what happens when I die. Well, we really focus at Cunningham Legal on what happens if you become incapacitated. What happens if you have dementia and one of your kids or some type of successor has to take over your world and has to manage your assets and manage your financial decisions and your healthcare decisions. I'm sure, Jim, you've seen that too over your whole career.
Oh, I'm living it. My mother-in-law just passed away a couple of months ago after a very long battle with Alzheimer's, and my father-in-law lives in assisted living about a block and a half from our house. So unfortunately, he's on quarantine, so he can't come over. But yeah, I mean, we're living the dream. I mean, I'm going through this personally, so
yeah. All right. So I guess a little bit of background in case anybody has never worked with estate planning before, trust before. These are the terms we're going to refer to throughout. So a grantor is a person who sets up the trust. That's the person who made the trust. You'll also hear him referred to as a trustor or a settler. We're just going to call him a grantor today. Now, the trustee, I call that the human representative of the trust. I think Jim refers to the trustee as the person who signs on behalf of the trust. They both work for me. But you have a trustee and you have somebody who's acting trustee. Most likely, the grantor is going to be the trustee when the trust is set up. But there's always going to be a successor trustee named, and there's going to be an alternate successor trustee named as well. And these different positions we're going to come back through today. But typically, like, your normal family, you'll have a husband and wife, and they will be grantors. They'll name themselves as acting trustee, but one day they expect to become incapacitated or pass away, and they'll have their successor trustee named, probably one of their kids, and then a backup to that trustee as well. Now, I do want to note, I saw someone raise their hand. We have a pretty large crowd today. I think we're going to mostly hold questions and answers towards the end. So if you look at your box, like your bar here, you'll see Q&A. If you type questions in there, we will definitely get to them at least by the end of the presentation today. Depending on how time goes, we might try to answer some as we go through, especially if we see good ones, but we will definitely answer them by the end of this presentation today. All right, so continuing through. Now, a lot of people, when they think of a trust, they just think of a pile of documents, and they think, oh, I signed this and I'm good to go. But when you set up a trust, you're trying to do two things. You're trying to avoid probate, and you're trying to prepare for incapacity. You're trying to put your successor trustee, your kids, whoever it is, in the position to manage your assets if you do become incapacitated or if you pass away. So you have to make sure that your trust is funded. Jim, what does funding a trust mean?
Well, it's certainly not fun. I mean, fun is part of funding, but it's can be pretty tedious. So if you can think of a living trust as a bucket, right? So I have this bucket, this little miniature bucket here. And what I do is my wife and I set up this living trust bucket. We're the trustees. We're in control of it. We're in charge. It's like, you build a ship, you're the captain of the ship. So my wife and I, Lori, are running this trust. We're the trustees. And into this trust, you're going to put assets, right? So you're going to put your house into the name of the trust typically, 99% of the time. That is funding, transferring the title from Jim and Lori to Jim and Lori as trustees of their trust. And then when Jim and Lori die, the successor trustee will be the one signing on behalf of our estate or our trust to sell the house, for example. So, because we'll be dead, we're not around, we can't sign the paperwork to sell the house. That successor trustee or that alternate successor trustee, that alternate captain of the ship, is the one who signs. In order for, and this is very important, please pay attention, in order for a trustee to have power over trust property, the property must be titled in the name of the trust. So let me say that again. In order for the trustee to have power over the asset needs to be titled in the name of the trust. So with a piece of real estate, you do a deed. With a bank account, what do? Well, you go down to the bank. You have to show up in person now. It was not the case 25 years ago when I started practicing law. It was a different world, right? And so now you need to go down in person to the bank, show them your photo ID, show them the trust, and there's a whole process that they'll have you go through. But bank accounts, real estate, your stocks and bonds, some people still have certificates. They'll come into our office and they'll have, shares of AT&T from 1975. Well, of course, that's a bunch of different companies some have gone out of business and some have merged into others. Some people have a share certificate, and something that's very important. If you have a share certificate, if you lose that certificate, and believe me, it happens all the time, there is a 3% fee to reissue a certificate. So a lot of people don't realize how important it is to keep those certificates. It's actually better to go with a financial advisor, and you can essentially move those certificates to the financial advisory company and they hold them for you. But we had one case where there was a missing stock certificate. It was a single piece of paper that was not able to be located, and it cost the family $30,000, 3%, $30,000 just to get a new certificate. So very important to pay attention to funding.
And Jim, you talked about how the world has kind of changed the last 25 years, how it's not like it once was, where you have to go show your photo ID. I think a big theme to our presentation today, and especially for the kids, adult children listening, is we live in a world where everybody is really concerned about financial elder abuse. And you have to make sure that your tracks are covered. You have to make sure that everything's set up, because people like bankers, they're going to be expecting financial elder abuse, quite frankly, these days. They're going to look for something to go wrong, for something not to be in place. So you do have that uphill battle. Now, I meet with two types of clients, it seems like. I have clients that have everything titled in their trust that should be in their trust. And then I have clients that just have their house in the trust because the attorney put it in. And everything else is outside trust. You, as a successor trustee, you can only manage what is part of the trust. So it's really important to retitle. I do get clients all the time that say, I have a pay on death, I have a transfer on death, a POD, a TOD. I don't need to put my accounts in trust because my banker told me that works just as well. Well, like I said, you are preparing for incapacity. And if you just have a POD on these accounts, that's not preparing for incapacity. With a POD, you as successor or as beneficiary, you only have access to the account if you have the death certificate. Our most frustrated clients are children of our original clients whose parents never retitled, who put these accounts with a POD. And that's because they get locked out of their parents' accounts and they need to manage their parents' lives. They have to pay for stuff like long-term care, and they can't do so because the accounts aren't part of the trust. The bank won't give them access. So and when that happens, they oftentimes need to get a conservatorship, which is something you're trying to avoid with a trust.
All right, let me just say very quickly, you will see POD or payable on death accounts, typically with bank accounts. You will see TOD, typically with brokerage accounts. And so that's the difference. Pay on death or transfer on death. But it's very important to understand that a POD or a TOD is not a plan. It is an instruction to the institution that if the person who is named as the payable on death transferee or the payable or the transfer on death transferee beneficiary, if that person shows up with a death certificate, they get the money. That's it. So if your mom needs to, or your dad, you need to pay for their long-term care, and there's some assets in a trust and some in a POD, there are very complex rules on which account you should take from first. Okay, so this is very important. And if you're the one who's in charge of the finances for your parent, you better look around and look at who the other kids are, look at who the other beneficiaries of the trust are, and you really need to do an assessment of, are these people going to sue you? I mean, that's the bottom line, and it happens all the time. Siblings suing siblings. Are they going to sue you? Are they distrustful of you? Are they crazy? Right? So there's a whole bunch of considerations we go through before a child takes on the mantle of being a trustee while their parent is alive. We haven't even talked about passing away, but while they're alive. But it's very important to understand you cannot manage those funds while the parent is living if they've got a POD or a TOD. There's a quick question here. I'm going to cover these questions as we do them because this is a quick question. If you want to make sure, Ron and Mary ask, if you want to make sure a specific son gets mom's house, should it be titled outside of the trust? And if so, how should it be titled? Typically, those are titled in the name of the trust. And there are a couple of mechanisms to get the house to the kid. The big question, the big threshold question is, do you want to treat your children equally or do you want to treat them not equally, right? So the question is, do you want that one son to get the house and have that form part of that son's share, or do they just get the house and whatever's left over gets divided equally? So that's part of the counseling aspect to estate planning that we would help your parents through.
And just, I want to tack on with deeding, if that's something you're thinking about doing, deeding a child to a house, there are negative tax consequences. And I'm not specifically replying to this question, but people ask me all the time, should I deed my house to my children? If you deed your house to your children, we're going to talk about this a little bit later, they will not get a step up in tax basis or a full step up in tax basis once you pass away. So what that means is the IRS will treat them like they bought the house for however much you paid for the house. And if they sell the house, they will realize a lot of capital gains. All right, so let's continue on. How does incapacity work? So if somebody becomes incapacitated, like let's say they break their hip or they're diagnosed with dementia, they have diminished capacity, most of the time it seems like the grantor resigns as acting trustee and the successor takes over. But that is not always the case. Sometimes by the time the grantor comes into our office, they're already incapacitated. Yeah. We always give them our test, try to figure out if they know what's going on, and not always they do. So what happens in that situation? Well, you have to look to the trust. How do you remove a grantor or trustee for incapacity? Now, a lot of old trusts, they'll say you just have to go to court to get instructions. We acquired a firm last year, and that's what their trust says. And it's been tedious at the least to remove a trustee. Now, most trusts that I see, they have a traditional method where a physician or two physicians, they say that if one is incapacitated, they are to be removed as trustees. So in these situations, we would have the child or the successor trustee get a doctor's letter saying that the original trustee is incapacitated and they're removed. A modern method of removing a trustee is the use of a disability panel. And what that is you name maybe your spouse and your kids or two of your children to vote to remove you as trustee. So in this situation where you have a spouse and two kids, they would come into our office and they would all sign a paper saying, oh yeah, our father is incapacitated. And at that point, we would remove the original grantor as trustee.
Going to court, by the way, in that context, is in legal fees, probably $10,000. And you go to probate court to do that. And that is not a modern way to do it. I happen to like the disability panel because what ends up happening is you will have a parent come in, and this is such a difficult thing to go through. My father-in-law is a retired Chief Master Sergeant from the United States Air Force, which is an E9, which is the highest enlisted rank you can get. And I was surprised. We went to the Air Force Academy. We were at a wedding, a family wedding, went to the Air Force Academy years ago. And I've only really known him as this old guy, right? And he liked to work on cars. His hands were greasy. But, I mean, he's a very smart guy, right? And we went through the gate at the Air Force Academy and they looked at his ID and it just snapped to, all right, Chief, go through, because that is a very high rank to attain that very few attain in the military. And he is not aging well. He's 88 years old, and it's been really hard on my wife. She's had to see her parent, both her parents, frankly, decline. But I will say this is probably one of the top 2 or 3 issues when clients come to us. They say, my mom or dad is really slipping, and they're not cooperating. They're being kind of not combative, but they're really not going along with the program. That is a whole other topic. So we're not talking about that. We're just talking about as long as everyone's compliant and going along with relinquishing some element of control. But many elderly people do not want to relinquish control, and it can be a big source of conflict in the family.
And that decision can be really intimate, which is why we call it maybe a modern approach, because people out there, they'd rather have the family make that intimate decision as opposed to a physician that they don't know that well.
Yeah, and then the physician says, you're incapable of handling your own affairs, which is very difficult for many elderly people to swallow, versus, oh, I will let you, yes, I'll go along with it, and we'll have this family statement, if you will, saying dad is relinquishing his control over his affairs. And that is a more sanguine way of getting to the point of having the kids take over. That's where the child becomes the parent, right? The child becomes the parent becomes the child. That can be a difficult transition.
All right. So what happens if a parent actually is incapacitated? So you as the child, you as the successor, do you know which financial institutions your parents use? Now, once again, we meet with 2 types of clients, the people that know where everything is and the people that expect someone else to keep a list of where the assets are. Nobody's really keeping that list for you, maybe besides your parents. When our clients come in, we try to encourage them to let us scan their financials. But not everybody wants us to scan their financials. Some people keep it to themselves. They don't want to bring it in. And then other times people change institutions. They change every few years. We have lots of clients that look for that high interest rate, or whatever we call a high interest rate in 2020. And they run around from institution to institution. Do you know how to access your parents' information? Do you know what their passwords are if they do online banking or if they have online only accounts? If you don't know this, it can be hard. I mean, traditionally, people wait for mail to come to find out where their parents' institutions are. But these days, half the stuff is paperless. So it's not super easy. As your parents get age, make sure that you can really pick off that baton when it comes to the time where you have to take over. Now, we also focus on supporting documents. We've been talking strictly financial documents and financial situation up until this point. But at our firm, we also focus on healthcare decisions. Your parents, if they have an estate plan, they should have an advanced healthcare directive. Now, those directives, they sometimes expire. Another law firm that we acquired a few years ago, they put an expiration date on their healthcare documents. You have to make sure that yours are current. Has it been submitted to a primary care physician? A lot of my clients, they keep their documents in a safety deposit box. And if your parent has an issue and they go to the doctor and that healthcare directive is in a safety deposit box, you're not going to have access to it, especially if it's on a weekend or a holiday or during COVID. I mean, that's a big theme of estate planning now, is nothing is accessible. I think for most people, to get into their safety deposit box, they have to make an appointment. Do your parents have long-term care insurance? A lot of our clients have long-term care insurance, but you have to make sure that you have that squared away so you know what your options are if your parents are incapacitated. Do you know if the policy's been reviewed? These things change all the time. I think, Jim, you know how much they change the long-term care insurance policies.
Yeah, and I would say there's been a change in the last few years. Many of our clients have the Calpers long-term care policy, and a lot of our clients are state workers or teachers or retired safety workers. And many people have a Calpers policy. Well, that type of policy is one where you pay as you go. It's you use it or lose it. You pay $300 a month or $500 a month or $5,000 a year, whatever the number is. You pay. And recently they increased premiums 85%, which really upset a lot of people because that was a big increase. That's one way to do it. A more modern approach is to take some cash, maybe $50,000 or $100,000. And what you do is you give that money to an insurance company, you write a single check. And if you never use that money goes to your kids as a death benefit. All right. But if you do use the money, then they get less. But you also, if you put in 100,000, you might be able to get 300,000 in coverage or 500,000 in long-term care coverage. So the younger you are, the more coverage you're going to get. And this is a really powerful tool. And this is our last slide on incapacity. We will get it to when people actually do pass away. But this is our last slide on incapacity. And I do want to say that we see a broad range of what people pay. My father-in-law is in assisted living. I think his bill is about $6,000 a month. We have some clients that are paying. We have a client in the Bay Area who's paying $40,000 a month for his father-in-law and mother-in-law. He's an extremely wealthy guy. That's kind of the range, right? Is it's kind of 5 to 40. You might be able to see, get some in the 3,500 range, but the average stay in a nursing home is 4 years. So when you take, $8,000 a month, and the average in California is 10 times 4 years, that's $500,000. You need to look at the $500,000 and the assets that you have, and sometimes those don't line up totally, and you need a little bit more money. That's the benefit of long-term care insurance. Is it's not necessarily to pay for all of the care, but it's to help sort of fill that gas tank up, if you will, because I liken long-term care to a journey of an indefinite length, right? You say, all right, you're going to take a drive. Well, okay, I should leave with as much gas in the car as I can because I don't know how long that drive's going to take me. And some people do outlive their money, and some people don't outlive their money. So I think it's something that I would, if I was a child, if you're a child on this call, you really need to have that discussion, and you can, we're certainly happy to help you with that or send you to the right person who can help you. But have that discussion about long-term care because, no one wants to stick their parent in a Medi-Cal facility where the state pays because those are terrible places. But the nice thing about long-term care insurance is you insure that risk. It's kind of like if you have a car paid off that's, not that old, you'll still have collision coverage. Same thing with long-term care insurance. Warren Buffett has 2 policies of long-term care insurance. So he's a rich guy and he has long-term care insurance. So if it's good enough for Warren Buffett, I think it's something you guys should consider. And we do have Anita on this that Jim is discussing, long-term X amount to insurance. Is this an annuity? It can be structured as an annuity. What we see many times is it's structured as a life insurance policy with a long-term care rider. If you have an existing annuity, and this is really important. So for those of you who already have an annuity and you would like to get long-term care insurance, there is a way that you can take that annuity and exchange that into a long-term care insurance policy. So you can use an existing annuity, which is a very powerful tool because, and we'll talk about taxes in a minute, when you take a distribution from an annuity, you're going to pay tax, okay, by and large. If you take a distribution from an annuity that has a long-term care benefit, there is a significant tax advantage, and that's a recent change in the law. So if you have an annuity and you're concerned about long-term care, please reach out to us. We can connect you with the right people to help you with that. But thanks for asking, Anita.
Okay. So just like Jim said, we are going to shift away from incapacity and talk about what happens when somebody dies. And with trust administration, that's typically what we call the point where somebody dies and we have to get assets out of the trust and into a beneficiary's hands. There are just so many different obstacles, and they all vary from client to client. But we're going to focus on two today, mostly on the taxes part. But I do want to mention notices because a lot of people, they don't know about notices when it comes to trust administration. So every person, every beneficiary on a trust, once the two grantors or the grantor dies, they have a right to see the trust in California. They have a right to see the trust, they have a right to contest the trust, and they have a period of time to do so. And that period, the time only starts once they have this notice, this 16061.7 notice. And that's important to issue once somebody passes away. It's a notice that's sent by service of process. Now, if someone's disinherited in a trust, they also have a right to see the trust. And I always try to stress this to my clients. A lot of clients, for whatever reason, they romanticize estate planning. They come in and they have this preconceived notion about how everything should be. And it's important that you actually strategically work with the law so you're not over noticing. A lot of our clients too, they come into our office and they have prior amendments done on a trust. So, they had their first and second amendment, and then they did a third amendment, and that third amendment just wiped out whatever was in the first and second amendment. So beneficiaries on that first and second amendment are no longer receiving anything in that third amendment. Well, even though they're not receiving anything, since they were referenced in that first or second amendment, they have to receive a notice. And so what I'm saying here is, if anybody's in your estate plan, they're going to receive notification once you pass away, and that can create an awkward dynamic for a successor trustee and non-inheriting people. I think it's important strategically to make sure that your trust is up to date so that you don't have to force your kids in a position to share this private information with people who you might have had a falling out with, or just people in general who don't deserve to see the trust.
Yeah, and something you guys, for those of you who might be named as successor trustee on your parents' estate plan or someone else's estate plan, something that you need to be very mindful of is you're under no obligation to serve as trustee. So the 13th Amendment to the United States Constitution abolished slavery. And this is I'm not kidding. I mean, it abolished slavery, everyone knows that. It also abolished something called involuntary servitude. And the bottom line is, unless you take up the role of trustee, you don't have to, okay? It's just because your parents name you doesn't mean you're the one who's gonna have to do all of that work, and it's a lot of work. The other huge part of this is you are 100% personally liable for everything that goes wrong in an estate administration. Now, what could possibly go wrong? A lot of things, and we're going to talk about taxes in a minute. But if you make a distribution to the wrong person, which you might not think is a big deal, but if you say, hey, I went to my accountant and my accountant said, oh, this is really easy. There's a trust. It's clear. Just write checks to all the people. Don't worry about it. If you never send out that 16061.7 notice, you're never starting that statute of limitations, you can be sued if somebody challenges the estate plan, right? Someone steps forward and says, I think that was the product of fraud, duress, menace, undue influence. That wasn't mom and dad's signature, whatever, right? If they win, you're personally liable to give them what the court says they're entitled to, and you are prohibited under California law, prohibited from going back to the people that you gave the money to from the trust. You're prohibited from getting that money back. There's no legal basis for you to get that back. So that's one example of personal liability. Another huge example of personal liability is not paying taxes. And you may think, well, mom and dad never filed taxes for 2 or 3 years, so I guess I don't have to file taxes. That is absolutely wrong, because death can result, even if your parents are low income earners, right? Death can result in the need to file a final income tax return, because there's something called income in respect of a decedent, IRD. You talk to most estate planning attorneys, they don't even understand it. That's what Connor studied for a year. Income in respect of a decedent. If you have an annuity that's paid to your estate, that may cause you a big income tax bill. So the bottom line is, you really need to pay attention to this. You really need competent legal counsel. And I was just looking at a report this month. Many of the people that we met with this month had a single meeting. And at that meeting, we kind of looked at everything and said, there's nothing to do. We had a whole lot of other people where there was a lot to do, right? So it's important to check in with a reputable lawyer, which is obviously us, but check in with someone who knows what they're doing to find out what it is you need to do, okay? And that's very, very important.
Okay. So now I guess a big part of this that we've all been waiting for is taxes. And what type of taxes are due when somebody inherits, when somebody passes away? There are really 4 different taxes that we're going to talk about today, and they all deserve their own special attention. Capital gains tax, property tax, which is super popular in California, Proposition 13, income tax, and then finally death tax. So let's, I guess, start from the top, capital gains. And capital gains, what that's going to be is when you own a capital asset, like a house or a stock, and it's not in a tax-deferred account, you sell that stock and you have to pay gain. You bought the stock for X amount of dollars and you sold it for Y dollars. And that gain, that difference, you're going to pay tax on. And currently in California, you're going to pay, for most people, 15% federally. And then for a lot of Californians, 9.3% to the state, ordinary income to the state. So I always think 24.3% is a good number. And on a house, the house you live in, if you're married, when you sell your house, you get a $500,000 exemption. And if you're single, you get a $250,000 exemption. And that's great if you live in Iowa or even Florida, but in California, especially the LA area, a lot of my clients, they've had appreciation like that. I mean, gosh, a lot of my clients in Pasadena, they bought a house for $200,000 back in the 70s, even the early 80s, and now it's worth over $1 million. And if they sell, they have a big capital gains bill. So that's capital gains. Now, when somebody holds their property in a trust and they live in a community property state like California, when the first spouse dies, the surviving spouse typically gets a step up in tax basis. So I'm going to be talking about step up a lot. What a step up is the IRS and the Franchise Tax Board for California, they no longer treat you like you bought your real estate or your stock for the amount you did. They treat you like you bought it for fair market value on the date of death of the first spouse. And also, okay, on people who inherit, when they inherit stock and a house, they typically get a step up in basis on the date of death of their parent or of the grantor of the trust.
So Connor, what you're saying then is, if mom and dad buy a house for $200,000 in Pasadena, and it goes up to $1 million, Pasadena, California, not Pasadena, Texas. It goes up to $1 million. If they were to sell that house, they'd pay some capital gains tax, right? Because 200 plus 5 is 700. So that nub of 300, right? You'd pay tax on.
24.3% is probably what they're going to pay on.
And if the husband dies, the wife can sell that property for $1 million and pay no tax. And then that property could go up to $2 million in value. And when mom dies, the kids inherit that property and they're not paying $300,000 in taxes. They get that tax-free, right?
That's correct. That is exactly how the law stands.
That's what we're talking about.
Yeah.
Except if it's a B trust. And if you have a B trust, you need to look at getting rid of that. But we won't talk so much about the exceptions here.
Yeah. So that is your general rule. Now, that's not automatic. It's not like the IRS just assumes everything was in place when somebody dies. That's why whenever a parent dies, whether it's the first parent or the surviving parent, the property has to be appraised. It has to be an appraisal through an accredited appraiser. And that way, once you do sell that property, you can show the IRS how much your gain was based off of that appraisal.
Yeah. So this, the IRS isn't doing all this work for you, right? You need to do some work. And this is why we're busy when people pass away. We're busy as lawyers because there is stuff to do. That's the bottom line. And can you do this on your own? Not really. You really can't. Is this a job for, can you go out and get your own appraiser? Well, maybe, but you should have a lawyer coordinating all of this activity.
And it has to be that accredited appraiser. What happens if you don't get an appraisal, Jim, and you sell the property?
Well, here's the deal is all this stuff ultimately gets submitted to the IRS. And if I'm an IRS agent and I'm looking at two tax returns, and one has what's called a BPO, which is a broker's professional opinion, which is typically a paragraph saying, I think this property is worth $1 million. Or you have a very detailed, maybe 20 or 30 page appraisal that says, I'm a certified appraiser and this property is valued at $1 million. Which one is more likely to be challenged by the IRS? And one thing you never want to do is a forensic valuation. That's very expensive. Forensic valuation means going back in time 6 or 7 or 8 or 9 years, right? You don't want to be doing that. So you want to, what is a residential real estate appraiser, Connor? $500, something like that, 300, 500, 800.
Yeah, I see 500 all the time.
It's peanuts. When you look at it in the scheme of things, it's really a small amount. But I would say, 'cause we do get questions, hey, what about a broker's professional opinion of value? If you have a $15,000 property in California City, that's different than if you have $1 million home in Pasadena. So,
yeah, that's exactly it. All right. So property tax, this is the big one in California. So Proposition 13, just for a little bit of background for those who don't know it quite 100%. When you buy a property in California, your property tax is based on the acquisition value of the property, not on the fair market value like every other state for the most part. So our same example, you have your family who bought the property in Pasadena for $200,000 back in the 70s. If I bought that property for $1 million today, I would pay $10,000 a year at least. But they are probably paying something like $3,000 or $4,000. That 200,000, that's their acquisition value. So you pay 2,000 on that, but every year it goes up for inflation about 1%. And so they're paying probably 3,000 or 4,000 a year. So basically, if you've owned real estate for a long time in California, your property tax is probably going to be pretty favorable. And that's not just on your principal residence. That's going to be on all the real estate that you own, even if you own commercial real estate, at least for now. We're going to come back to that. Now, on your house, you could have a $10 million house or a $20 million house. Whatever you pay in property tax, you can pass to your children, or at least in theory, you can pass it to your children. If you have one child, you can definitely pass it on. If they want to keep the house, they will not be reassessed, regardless of how much the house is worth. Now, once again, this is not automatic. It's not like the county doesn't want to reassess. They probably want to reassess more than the IRS wants to tax you. So you have to make sure that you follow their rules and you properly document the transfer within the period of time that's required. That's the other part of trust administration, making sure you do that. Now, what about a second house or a third house? Or if you own vacation property or if you own commercial property? Currently, under our 2020 law, if you leave these properties to your kids, they do not get reassessed on up to $1 million in base year value. So I have a couple clients, I have clients specifically that came from Greece back like in the 50s or 60s, and they just started collecting property in California. And they probably have 10 properties, and they bought them all for like $50,000, $60,000, maybe even $30,000. They're going to pass on all 10 of these properties to their kids, and only one of them will get reassessed, partially reassessed. The other 10, no reassessment. But if you're someone today and you go and buy one property for $1 million, and by the time you pass away and it's worth $3 million, you've burned through it all. So this law really does favor people who've owned their property for a long time. And as a result, it's a somewhat controversial law, of course.
I think,
go ahead.
And Connor, I'm glad you're mentioning this. I think preserving Prop 13 is an extremely valuable property right for people who are inheriting property in California. You want to keep Prop 13. However you can keep it, you want to make sure that gets done. And here's something to understand. You mentioned the assessor wants or doesn't want to reassess the property. Here's a fact. When you die, that is considered a change in ownership. property is reassessed when there is a change in ownership, period, unless you have an exclusion from reassessment, right? So what the kids have to do, and it literally is a race to the assessor's office, okay? It is a claim. It's like the gold rush, where in Placerville in the gold rush, the claim was a shovel width, which is like three feet or something. I mean, this is like gold rush days, right? It's the first one who gets to the assessor's office in each county where the property is located and files a claim for reassessment exclusion. It's a form you have to file. If you don't file that form, or you don't timely file the form, you'll lose your ability to pass that property parent to child free of a reassessment. And the person who was behind this parent to child reassessment exclusion for the primary residence of any value was Dianne Feinstein. Dianne Feinstein has a home in San Francisco on the Lions Street steps. And for those of you who've been to San Francisco and wanting to do an urban hike, it's an absolutely gorgeous walk. Pacific Heights, gorgeous view of the Golden Gate, gorgeous view of the bay. The property is probably worth $30 or $40 million. She will be able to transfer that property to her kids and not have it reassessed, saving her family literally like $500,000 a year. It's insane. It's a crazy savings. Now that's a huge outsized example, but we have so many clients where, you know, the kids might be teachers in West LA. There's no way teachers can afford a house in LA. If you can get that house in Westwood, that $3 million house, then the tax bill's maybe, you know, $3,000 a year or $4,000 a year. If you can take that house and preserve that $3,000 or $4,000 a year tax bill, that is a huge benefit, because you'd otherwise be paying $35,000 a year in taxes. You're literally saving $30,000 a year. So it's a tremendous blessing, tremendous benefit.
Yeah, it's a way that a lot of people keep money in their family. I do want to dispel a myth with Prop 13. I always have a lot of clients who tell me how simple their situation is. And one of the simple situations is when somebody, you have the mother or the father, the widow, the widower, they own their house, they own it outright. It's worth, $900,000. And they have two kids, and they know one of those kids wants to keep the house. They don't have really much anything else in the bank. So that's their estate, it's really the house. And they want one of the children to buy the other out. That's their whole plan. In California, if that's what happens, that is considered a change of ownership, regardless of whether it comes from the trust or not. And there is at least a partial reassessment. Part of trust administration is, for a lot of our beneficiaries, we're able to help them structure the trust so that they can potentially get around this reassessment by taking a loan on behalf of the trust, paying it off, all that good stuff, but avoiding the reassessment. That is a common thing that happens when people's really big asset is their home, and they want to make sure that one of their kids gets to keep it and doesn't get reassessed. I also got an email from one of our staff members about somebody who sent in an email before this presentation today, and I believe I can recap it properly. This person inherited a house from their parents, and they took their parents' base year value in their house. So they're paying pretty low property tax, I'm going to expect. And then they sold the house, and they bought another house in a different county under Proposition 90, like you can see here highlighted on my screen. They bought a house for equal or lesser value, and they brought their parents' low property tax base year value with them to this new house. And they asked, can I transfer this base year value to my children? And under the current law, yes, you can. That might change by the time we all pass away. But yes, that is a way. That's how people keep money within their family. And that Proposition 90, I should have probably gone into that a little bit better. If you live in certain counties in California, if you downsize or you buy a house of similar value, you can take your original base year value with you. Okay? So a lot of our people, they inherit a parent's house. And just like this person who sent this question, they essentially sell it. They buy a new house, they live in that new house, and they get their parents' base year value. So these are all things that you should plan for, and they all require thought. Otherwise, you're just going to rely on luck to really benefit from this law.
Yeah, and so I will tell you, when you kind of take a high-level look at this, what we find are many people who are inheriting are either already retired or going to be retiring soon. And my My dad's a retired lawyer, successful guy. He retired at age 76. He had to move to Texas. Oh, my aunt's there. It's not that he had to move to Texas. He and my mom wanted to move to Texas. But by moving to Texas, they were able to retire. Many people simply cannot retire in California, period. Our income taxes are too high. If you're looking at buying a piece of property, the property taxes are high. It may be cost prohibitive for many people to retire in California, or they might have to work a few more years before they retire. This is just one of the things that is part of your legacy. So if you're a parent watching this and you're thinking about your kids, this is I would say a hidden asset that many people don't really quantify and put into dollar terms. But if you're paying $20,000 less in property taxes for 20 years, that's $400,000. That's $400,000 that less that you have to be spending in retirement. And it may be the difference between staying in California, maybe closer to your family, or moving to another state, frankly, that has a lower tax bite.
Okay, and then we have our question. Does this transfer of base year value also apply if the property is held in trust and then inherited by children? Yes,
Yeah.
if it's inherited by children, whether it's in a trust or not, they can take this base year value if they properly document it with the assessor's office.
Yeah, and again, this is not legal advice because I think a lot of other attorneys would spend about 15 minutes on this explaining all the exceptions. As a general rule, yes, but there are a lot of ways to screw it up is the bottom line.
That's true. Generally, yes. Okay. All right. So then a lot of our clients are asking us now about Proposition 15. So Proposition 15, this is going to be on the ballot in November for California. And like I said earlier, Proposition 13 is relatively controversial. So especially this part, bear with us here. We just looked at the actual black letter law before this presentation today. And it's 13 pages long, and it hasn't been approved by the judiciary. So it could be shifted. But this law, a lot of money is going into it. If passed, Prop 13 will be changed so that industrial and commercial properties will be reassessed, even if you own it now, every year, excluding commercial agriculture. And they'll be taxed on their market value as opposed to their purchase price. This is known as split roll. It's been in the works for probably as long as Proposition 13 has existed. There are some exceptions here. The one that's highlighted the most is for business owners who have less than $3 million in holdings in California. Now, even if this law passes, and right now it's narrowly favored to pass based on polling, it will probably be tweaked and it won't be totally rolled out for a few years. But this is something that you should look into for the ballot in November. It will generate income. They expect it to generate 8 to 12.5 billion per year. Now, if you so what this is basically saying, if you own a house, at least at this point, you're fine. You're not going to get reassessed in your principal residence.
For now,
Exactly. Even if you own that second house or you own rental property, you're not going to face the reassessment either for now. This is for commercial or industrial properties. So that's going to be if you own a strip mall, right? If you own a restaurant, if you own warehouses, those are the things that are going to get reassessed. I know that the people who are big advocates of this bill specifically are focusing on corporations. They want to make sure that, like, your local golf course gets reassessed, or Disney gets reassessed, or the LA Coliseum gets reassessed.
Yeah, I mean, like Disneyland is under Prop 13.
Yeah,
I mean, which is kind of crazy. I mean, if you think about it, like, what? That's kind of crazy. The politics aside, these very large corporations, their property is never reassessed. But when you're an individual and you die, the property gets reassessed. We do have a question. I just want to loop back on this. Gail asked, does non-principal real property get reassessed when passed to children? Gail, I'm very glad you answered this. I'm going to repeat what I said. Whenever there is a change in ownership, which is a death or a sale, but a death is a change in ownership, the property is reassessed unless you make a claim for a reassessment exclusion. In this case, non-principal real property is limited to $1 million in what is called full cash value. You can think of it as assessed value for 99.9% of the cases, unless you're a disabled veteran or something. There's some carve outs on that. But the full cash value or the appraised value. So if you have an apartment building that's worth $5 million, but has an assessed value of $1 million, you would be able to transfer that to your child through a trust at death and not have that property be reassessed at all, but the child would have to make that claim for reassessment exclusion. And our firm, obviously, we're helping people with that because this is very confusing stuff. But that's, so the answer to your question is it does get reassessed unless you file the exemption. So very important to understand. Now, if you're married, you can double up on the exemption, $2 million, but the problem is you have to double up correctly, because if you just leave everything to the surviving spouse and then that person dies, you lose that $1 million exemption. So if you're concerned about Prop 13, you need to pay extremely close attention, very close attention to the intricacies of your living trust. And I will tell you, we have other expert estate planning lawyers reach out to our firm because they know we know Prop 13, and they say, hey, can you help me with this Prop 13 issue? Many estate planning lawyers, forget the generalist lawyers, all right? And by the way, estate planning is the purview of experts. This is an experts only legal activity, like patent law, like bankruptcy. These are things that are very esoteric and very niche areas. Prop 13 planning is a niche within a niche within a niche. Okay, very few people know this, right? And you had a professor at with your LLM. Connor took a whole class on Prop 13, but he only got that when he got his advanced degree in taxation. So this is not something that's taught in law school. What is the time frame for reassessment exclusion after death? The time frame is 6 months to avoid a $180 fee per claim. I believe it's per claim. That's the paralegals would know if it's per property or per claim. I think it's per reassessment exclusion. If that avoids a $180 fee, if it's after 6 months but before 3 years, you can still claim it, but you have to pay the fee. If it's after 3 years from death, you're out of luck. And the problem is many people, you might have one kid out of 3, mom and dad died. Maybe that one kid was taking care of mom and dad. And the siblings said, Johnny, you can go ahead and stay in the house for 10 years. And don't worry about it. And they don't do anything. Well, guess what's going to happen? When that property gets sold, they're going to get a retroactive reassessment, right? They're going to retroactively reassess the property. And that's a supplemental unsecured bill. You have personal liability for an unsecured bill. So it's a big deal.
Yeah, so I mean, that's exactly it. Prop 13 is really its own field within estate planning, I suppose. Jim wrote a book a few years ago on estate planning, and I think the sequel should be about Proposition 13 because it is such a hot topic, and it really does matter when it comes to estate planning. Yeah, that's Savvy Estate Planning. That's on Amazon.
Savvy Estate Planning, and that'll be there'll be a follow-up email that you guys get, and there'll be a link to it. Savvy Estate Planning, what you need to know before you talk to the right lawyer. It's all the stuff to think about. And I will, just to close on Prop 15, and the reason we don't like to spend a whole lot of time on law that may or may not happen, but this one you really do need to pay attention to. I'm looking especially at that $3 million number in there. 2 things on this. One is 2/3 of the state of California's revenue comes from personal and corporate income tax. Do you think people are going to be paying less tax this year? Yeah, I think a lot of people, a lot of business owners I know are really worried about even staying in business. So I think California's revenue is going to be sharply down this year, the income tax revenue. And secondly, this $3 million, I could see there being a blanket exclusion where if your residence, I could see this in the future, if your residence to the extent it's over $3 million, you might get reassessed. So I could see this property tax issue getting more and more complex. So it's something you really need to pay attention to if you have real estate in California.
All right, so income tax, and we'll kind of get through these last ones a couple of times. Jim and I both have done quite a few webinars on income tax because of the Secure Act that passed last year. So if you inherit from your parents and you get a house or you get a brokerage account or you get a bank account, that's not taxable income to you. You don't pay tax on that because your parents already paid tax on it. But if you inherit an IRA or a 401k or a 403b or a 457 or a qualified annuity, something that's not a Roth retirement account, you are typically going to pay ordinary income tax on that account. So if you inherit an IRA, and for a lot of my clients, their biggest asset is their IRA. Generally speaking, because of the Secure Act, you have 10 years to pull out the money out of the IRA and to pay taxes on it. So if you inherit a $1 million IRA, you're going to pull out about 10% of that IRA every single year. So, the first year you're going to take out $100,000 and you're going to pay tax on it.
Right. You could, or you could wait 10 years. So if your parent dies in 2020, you don't have to take any money out. By the way, this is if you go through a lot of things and qualify, right? If you do it right, and there's this whole secret sauce in doing it right. If you do it right, you don't have to take any distribution for 10 years, meaning if your mom or dad, if someone you inherit an IRA from dies this year in 2020, you don't have to take your first distribution until December 31 of 2030. So that $1 million IRA hopefully will be 2 million. Then you take it all out and it's $2 million in tax to you personally, or $2 million in income, and you got to pay tax on that. That's a big tax bill. In California, it's about a $1 million tax bill. It's about 50%.
50.3% if you wait until that last year 10. So exactly. So I'm summarizing. Your strategy most likely should be that you take that money slowly, 10% a year, so you don't get bumped up into the highest tax bracket. And that's not the case for everybody. Once again, this is not legal advice, but it is generally going to be the case for a lot of people. And a lot of our clients, including maybe some of your parents, they use what's called an IRA legacy trust. And that is a special type of trust that provides asset protection for these IRAs. If you just inherit straight up from an IRA, if you get sued, you get divorced, your IRA is going to be part of the lawsuit. It's going to be part of the divorce. So check to see if your parents have that IRA legacy trust set up or whether they just have you named as beneficiary. Okay, so that is income tax. So just as a summary, retirement account money, the way I like to think about it, the money your parents never paid tax on it, the ones they took deductions on, like a regular IRA, you have to pay tax on as beneficiary. But if your parents already paid tax on it, you're generally going to be okay from income tax.
Ron and Mary asked, does the sibling file, I can't even see this. I got to borrow my glasses. Does the sibling file the exemption after the last parent dies or before the last parent dies? And I think the answer is whenever there is a transfer from a parent to a child. So if the first parent dies and the estate plan says this piece of property goes to the child on the first spouse's death, which doesn't happen that often, yeah, that's when you would file. But typically what we see mostly is everything transfers after the death of the second spouse. And then anonymous attendee asks, is the surviving spouse who inherited the IRA have to take it out in 10 years? Spouses have two options. You can do a spousal rollover, and that IRA becomes your IRA. And so you're treated as if it's yours. So there's no minimum distribution until you're 72. If you're 95 and inherit an IRA, you may want to opt out of the spousal rollover because it might be better to inherit. So it just depends on the age of people, but generally spouses will typically roll it over, with the exception, and this is a very important exception, if the inheriting spouse is under 59 and a half and they roll the IRA over and they're going to live on that money, that may not be a great idea because you're going to pay a 10% penalty for an early withdrawal if you do a rollover. So very important to pay attention to. Whenever someone dies and there's an IRA, you absolutely have to hire a team of experts, which is your accountant, your lawyer, and your financial advisor, and the three of them have to work together. What if you moved your regular IRA to a Roth IRA? Fantastic. That's great. The Roth IRA has no minimum distribution. So once you hit 72 under current law, there's no minimum distribution. And when you die, those kids can leave that money in the Roth for 10 years to grow, but all the money does come out in the 10th year, right? So if we're in 2020, all that money would come out on December 31 of 2030, but there's no tax. If they take the money out in 2020 and invest that $1 million, they're going to have to pay tax on the earnings. So I would say the headline on this is Secure Act encourages people to look at a Roth going forward. And it's all about tax bracket arbitrage. Well, what does that mean? Well, that means if you're in a 22% tax bracket, you may want to do a Roth conversion. So this is in addition to minimum distributions. You may want to do a Roth conversion before you bump up into the next tax bracket. So again, this is something that has made estate planning more complex. And if you think it's complex now, we're going to talk about death taxes, which is could potentially get even more complex.
All right, so death tax. So that's a tax on people once they pass away. Now in 2020, that exemption from death tax is $11.58 million per person. So if you don't have $11.58 million and you die in 2020, your estate will not pay any death tax. And if you're married, keep in mind, right now you can combine the 11.58 exemption to a little bit over 23 million. So very few people currently have any estate tax issues or death tax issues. Now, at the end of 2025, that death tax exemption is supposedly going to drop. Under the current laws, it's going to drop to about half of its current exemption amount. But already, this $11.58 million exemption amount, it is controversial, to say the least. Once again, this is part of the tax cuts that were put in place in 2017 by the current Trump administration. And as you can imagine, there are a lot of people who do not like it because the $11.58 million is so high. Now, last year in 2019, California talked about putting their own estate tax into place. It didn't go anywhere, but since then we've had COVID. And you might see a push to lower the death tax amount. Now, what will happen if Joe Biden is elected president and the Senate control shifts to Democrats? So Joe Biden laid out his tax plan, and we're going to reference it a little bit just because it's possible that he gets elected president. And what can you expect to happen? Well, he talks loosely in his proposals, but he talks about bringing the death tax, estate tax exemption back down to its historic levels, which is 3.5 million. Really, that's a historic level. It started to go up under the Bush presidency to 5.5 million. But either way, I would expect it to go down to 3.5 million. That's what Hillary Clinton platformed on in 2016. Bernie Sanders says the same thing. So that seems to be how much those people want it to be. Now, what happens if you're worth over 3.5 million and this is the law? What happens if you're worth over 11.58 million today and this is the law? Anything above that number is taxed at 40%. So some people have these death tax issues. Now, more importantly, for our clients, we talked about step up and basis. We talked about how when two people die and their kids or whoever their beneficiary inherits, they get that step up so they can sell their property for no gain. Joe Biden, his big talking point is eliminating the step up and basis in order to raise revenue. Now, he hasn't really released a tax plan on his website. He just goes around and does interviews, and he released a paper with Bernie Sanders to try to appeal to some of the Democrat base. And he talks about eliminating the basis for sure, but he has loosely said that he believes in taxing the unrealized capital gains at the time of death. So that would mean that if you inherit that house in Pasadena for $1 million, it's worth $1 million, and your parents bought it for $200,000, you might potentially have an $800,000 tax bill forcing you to sell that property once your parents pass away, or potentially forcing you either that or write a huge check. That's a possibility under the Biden plan. Now, it's unclear, and of course, politicians, they make promises that they don't always keep, or they back off from to try to appeal to more voters. Who knows what will happen? But here's all a possibility.
Yeah, here's kind of what I'm seeing looking at this, and again, I'm not one to really guess about what's going to happen in the future. But take your example of the person who inherits a property that's worth $1 million in Pasadena. First of all, when one spouse dies, as I read this, the surviving spouse does not get an adjusted cost basis. Doesn't happen. Whether or not the first spouse's death causes the surviving spouse some tax liability, it's possible that there, and we actually had the reason I'm spending time on this. This was the law in 2010. In 2010, what they did say is you get to an adjusted cost basis on $3.5 million of assets, but everything above that, you don't get an adjusted cost basis. Okay, so I could see a world where up to $3.5 million is kind of a free pass, but anything above that, what taxing your unrealized gain means is if you have this property that's worth $200,000, or that you bought for $200,000, that's now worth $1 million, you have an $800,000 realized gain. As we calculate it, the tax on that, the highest bracket would be 57.7% if you're in California. That would be the tax on $800,000. So more than half. So that is possible. Now, again, this might be something if it's above $3.5 million, but the reason we're covering this is to give you a flavor that if Biden does become president, I would anticipate a discussion about a change in the tax law, something you really need to pay attention to.
And we see a shift in society in general that I think we're all going to have to deal with. When I was in school, we're only talking 5, 6 years ago, they told me the tax code was there for two reasons. It was to raise revenue and to encourage good behavior, raise revenue through taxes and to encourage good behavior like charitable deductions, things like that. Now we are starting to see this period where there are people who want to wield taxation as a way to bring equality, to make sure that everybody is treated equally as opposed to raise revenue. And we're going to have to plan around this or plan for this for the rest of our lives, most likely. And that's really what we're talking about here, is what to expect if they change.
I want you to pay attention. The second from the bottom is eliminate 1031 exchanges. What that means is if I'm a real estate investor and I have bought an apartment building for 200,000 that goes up to $1 million, I can do a tax deferred exchange, and that's Internal Revenue Code section 1031. I can sell that $1 million building and replace it with another $1 million property, a like kind exchange, and defer my tax. That would be eliminated under this, under what we're talking about, if that does become law. I kind of doubt that would ever become law, but you never know. Another thing you need to pay attention to is modern monetary theory. This is coming out of the Bernie Sanders and his cohorts. Modern monetary theory says the government can print an unlimited amount of money and there will be no inflation, provided that the economy is able to absorb that money. So one of the things that happened when gold was discovered in California is the amount of gold coin in circulation increased 20-fold, right? So that was a huge amount of increase in circulation. It contributed to the second industrial revolution in the United States and in Europe, caused a great expansion of economic activity. So it's almost like the government in printing money is an alchemist, and they can create gold out of thin air. Now, whether or not you believe that or get it or whatever, that's what they're talking about. Why does this matter with Biden's tax plan? Taxation, to your point, Connor, where you said it's two purposes, there is a third purpose, which taxation is also a form of controlling the currency and controlling the redistribution of wealth. And so I really think that this is starting to get some traction with economists. So it's something to pay attention to.
Okay. So what does this all mean? In the future, generation skipping transfer trusts, those were a big deal probably 10 years ago. Those might make a comeback. And really, it's important to review your estate plan every 3 to 5 years. Things change. Sometimes we see things permanently change, like portability. That came around in 2011, where the IRS just allowed spouses to take their exemptions without splitting into different trusts. That's going to stay. Nobody wants to get rid of that because it makes everybody's life a lot easier. But some things do change. The estate tax exemption goes up and it goes down, and these IRA laws change, and this step-up law, that might change too. So you have to make sure that you do revisit all of these different things. Now, if you die with an outdated plan, it can cause issues. So make sure that you review every 3 to 5 years. At our firm, Cunningham Legal, we definitely let our clients know when there is a change in the law. You probably see that now, but just try to pay attention. Now, what to do now? So we are offering two things right now. And the first one is to set up an estate plan or update your own estate plan. Our firm, we do free consultations to set up an estate plan or to review and update your current plan. We do them via Zoom. We do them in office for the most part, and we're happy to do that for you. These meetings, they're a lot like this presentation here, where we just try to go through your plan, we tell you how we feel, and we quote you a price. Most of the people that go to these meetings become our clients, but not everybody does. Now, some of our people on here might want to set up a family meeting where they don't necessarily want to change or update their estate plan. They just want to make sure that their family is on track for what to expect once they start to inherit or start to run their parents' lives. And we'll talk about assets, whether they are in the trust, what successors should know to expect, what duties they're going to have. And for these meetings, we charge $395. Now, I do want to let you know that after today's presentation, you will all be emailed a link to this presentation today, and it will connect this presentation or YouTube video to the link. And more importantly, it will offer a $200 discount if you decide to set up an estate plan with us or to update your estate plan. So like I said, that $200 discount that you're going to get, that is for updating or setting up an estate plan. It's not for the family meeting. If you like to do a family meeting, we charge $395 for those. They take typically about an hour. And of course, we prepare for the meeting by reviewing your current trust. Now, if you choose to take a meeting, you have to bring your spouse. That's number one. And then you have to fill out our client questionnaire. Our client questionnaire, it is a 8-page document that asks about your financial situation. It asks about your financial situation, and it allows us to analyze your life. And that's how we are able to give legal advice, because we know what we're looking at as opposed to just blindly guessing. So that is essentially it. Jim, do you have anything to add?
Well, we'll open it up for some Q&A. Douglas says, thanks for the webinar, very useful. Hey, thanks for the compliment. I'm really excited about this family meeting because this is not appropriate for everyone. So it's not, well, what I mean is maybe not all the family members should be invited, but I think it's very helpful with the parents and the kids, is to come together and go through, okay, this is what the estate plan says. Okay, well, all right, so your mom's not doing well and your dad's doing a little bit better. Okay, well, this is what this might look like in the future. It's a really great opportunity for everyone to come together and be on the same page on what the estate plan says, because I just went through this with my mother-in-law, and I'm a lawyer married to the trustee of the trust, my mother-in-law's and father-in-law's trust. And there were a lot of questions with the family, and people just need to know what's going on. And it's very important to share, for many people to share that information. Carol says, I have a friend who should see this report. Is it recorded someplace that she could hook up to? Yes. We'll send you a link, and this is actually on this will be on our YouTube page, but absolutely. And thank you, Carol, for that. Anita says, very helpful information. Thank you, Jim, Connor, and staff. Well, thanks, Anita. Thank you for
And then really
your kind
quick,
words.
we do have our YouTube page. We have our other videos on there. Here's a screenshot from it. If you type in Cunningham Legal, you'll see our page, and you can subscribe, and you can watch our other videos. And this video will be on there probably within 24 hours.
Tomorrow, we have a great presentation. I highly recommend that you guys attend this. You can reserve for it on our website. It is an economic update. We have an economist from John Hancock Insurance, who is just a brilliant guy. He's going to talk about what's going on in the economy, right? What can we expect? It's like shifting sands. Every day it changes. My daughter's supposed to go back to Point Loma Nazarene University here in August, and we're early August. We're still not sure if she's going to go. So there's all this uncertainty going on, and this also kind of spills over to the economy. So they're going to give the sort of up to the minute economic snapshot. I highly recommend that you guys look into that. All right, so it looks like we've answered all the questions, and we'll just give it a couple more. Anyone want to put in another question? Connor, great job. Connor put together the slide deck. Good stuff. I think, feel free to shoot us an email and tell us what topics you would like to see, because we're always open for honest feedback from the people who attend these webinars. And anyway, great job, Connor. Thank you for attending. Have a great week.
If you do find this to be helpful, feel free to pass it on to anyone you think can benefit. Okay.
Absolutely.
Thank you all for coming.
All right, guys.
Have a great day.
Bye-bye.